you're my everything, yeah. My everything is you, Lord. Yeah. Ha-ha. Oh, 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 oh. Everybody say, ah. Say, oh, oh. Say, how can I express my gratitude for all the many things you've done for me? Words are not enough, yeah. Enough to say thank you. Say, Lord, you are my everything. You're my everything. How can I express my gratitude? How can I express my gratitude for all the many things you've Father, you done for me, yeah. Words are not enough to say thank you. Say, Lord, you are, you're my everything. Say, I call you Jireh. Lord, my provider. I call you Nisi. You are my banner. I call you Rapha. Hey. You are my healer. Say, Lord, you are. You're my everything. I call you Jireh. Lord, my provider. I call you Nisi. You are my banner. I call you Rapha. You are my healer. Say, Lord, you are. You're my everything. Uyamatingina. Uyamatingina. Uyamatingina.
Hello, hello, lovely people. Another wonderful Saturday afternoon is with us here in the BWTV studios, and we live with the program, The Community and the Law. My name is Wotker, Supreme Pon, and thank you very much for joining us. I entreat you to tell the other person to ask the other person to tell the other person that we are live, and we're bringing you another wonderful edition of the program. And it's brought to you by BWF Solicitors, our trusted partners when it comes to the law. BWF Solicitors, they are at Seven Sisters, North London, on the fourth floor of the Anna House. And what do they do? Yes, they work with the law, they deal in the law, they help you file all your applications and be on the right side of the law. Monday to Friday between 9:30 in the morning and 6 p.m. in the evening, they work. Call them now on 0208 493 7340, 0208 493 7340, or the emergency number 077 127 61884. I'd say the number again, 077 127 61884. Now, today I'm bringing you one very interesting discussion. In the past few months, people have been using the there are things that you need to do when you are putting in your application and also making sure that you stay on the right side of the law. Now, today, I'm going to bring you one very interesting discussion that will help you do things right. And no other person than a resource person from the stables of BWF Solicitors. My only friend, my brother, and my colleague, Charles Asma, will be my resource person to help us do the discussion. We have our nuggets to look at, and the quiz segment will also come at the tail end of the program. But in the meantime, let's say thank you to BWF Solicitors. Take the advert, and when we come back, we'll dive straight into the discussion.
This is our world. Here we are in our community. There are the laws, there are the regulations. We have BWF Solicitors. BWF Solicitors, experts in all aspects of the law, family law, civil litigation, all immigration and nationality issues, representation in court, marriage and divorce. We pride ourselves to give you excellent legal services and follow through till we get you the right result and decisions. That is our mutual satisfaction. We have a team of excellent qualified solicitors and support team to help you every step of the way. Our senior partner, with over 30 years of unbroken service to the community, is a member of the Family Law Panel and has advised several lawyers and institutions in many legal matters. He is qualified to practice both in the UK and in Ghana. Come to us. Speak to us. Let us represent you. We are your trusted community partners when it comes to the law. Locate us on the 4th floor of the Anna House, 214 to 218 High Road at Seven Sisters in North London, N15 4NP. Nearest train station, Victoria Line to Seven Sisters Station, exit number 2. We are open for all consultations from Monday to Friday, 9:30 a.m. to 6 p.m. Weekends by appointment only. Call us now on 0208 493 7340 or 077 127 61884. BWF Solicitors, your trusted legal partner.
Well. Thank you very much for sticking and staying. We're live on BWTV, and the program is the community and the law. Now, I'm going to take you through a lesson that BWF Solicitors dropped in the environment earlier in the week, and that is our nugget. And this afternoon, we're talking about immigration detention. And what is that? Immigration detention is the practice of holding people who are subject to immigration control in custody while they wait for permission to enter or before they are deported or removed from the country. It is not an administrative process, not a criminal procedure, but once the reason for detention has ceased, the detainee should be released. I would want to go over it again and then invite my brother, Lawyer Charles Asma, to help us digest that, unpick the details, and also know what it is that you do when you find yourself in that situation. Immigration detention is the practice of holding people who are subject to immigration control in custody while they wait for permission to enter or before they are deported or removed from the country. It is an administrative process, not a criminal procedure. But once the reason for the detention has ceased, the detainee should be released. Released to enter or released to go back to the country from which the person came from or what. Now, there's a case, UK Supreme Court of 2022 case, Hardial Singh Principles and Lumba 2011. Well, listen, I am not a lawyer. I need that explanation. So I will straight away go to my brother, Lawyer Charles Asma from BWF Solicitors to help us unpick that. Lawyer Charles Asma, thank you very much and good afternoon.
Good afternoon.
Immigration detention, what is that?
Right. So, as you earlier alluded to, it's a temporary holding of an individual or temporary subduction of the person's right in terms of freedom to do whatever they want to do.
Okay.
So the person is held away for a temporary moment.
Okay.
And temporary period could be any period, but the presumption is that the person is not going to be kept there permanently.
Okay.
And this is where the within the immigration rules, the Secretary of State feels that there is the need for investigation with a view to removing the person once they have entered the UK with a visa at the airport, or they're already in and the visa is cancelled, or they're already in but they have no status or leave to remain in the UK, and therefore there is the need for them to be removed. So we are saying that it's a holding up of an individual such that the person will have no freedom or liberty to do whatever they want to do at that particular point in time. And the period, and this holding up is for a period of time. As to how long it's open depending on the circumstance. However, what the law is saying is that there should be sufficient prospect
Okay.
that the person will be removed. And the second part is that there should be high level of certainty that the person will be removed. So if it's obvious that the person is not going to be removed, because we are not sure, or the Home Office, Secretary of State is not sure, then the certainty threshold is not met.
Okay.
And if it's a case of maybe, just like it's not sure, then we are saying that there's no sufficient prospect because there isn't enough evidence based on which you are sure that the person ought to be removed. So the question here is, how long are you going to put this person away or detain the person for, so that you hold the person's liberty? And we're also referring to Article 3 of the Human Rights Act 1998 and also European Convention on Human Rights. Article 3 deals with freedom from inhumane or degrading treatment, including torture. Even though detention does not call for torture, it's about holding up of somebody's freedom. And if you are holding away somebody's freedom to do whatever they have to do at that material time, then Article 3 comes in. Because you have rights not for your freedom to be prevented or hampered. So if somebody is going to detain you, then Article 3 is engaged.
Okay.
And the point here is, if the Home Office is not sure, can you be detained? And where they are not sure, the law is that you have to be given a bail so that they take time to investigate to be sure that your removal is indeed certain.
So let me find out what are some of the common reasons that the Home Office may base on to say that I'm detaining you pending investigation and probably subsequently removing you out of the country.
So somebody would, for example, enter the UK with entry clearance, we say visa. On arrival, the person is interviewed. And we have previously discussed the point where between the time you were given the visa up to the point you enter the UK, there's still power for the person at the airport, the immigration officer, to check to see whether the person who made the decision to give you the visa made the right decision.
Okay.
So when you arrive, you can be questioned on the same information that you provided. And they realize that there are discrepancies or there are issues that are not convincing enough, then they can conclude that even the visa was not issued validly to you.
Okay.
Then the law gives them the power within the rules to take it away by way of cancelling the visa and refusing it. Then you'll be given the right to representation or administrative review. Because it's an administrative process. We are saying it is not a criminal process where you have to be detained completely so that you don't come back to the community to cause harm.
Okay.
It's an administrative process so that they investigate to see whether you should be prevented from entering the UK or being in the UK or not. If it's an administrative process, then they have to get it right. If they don't get it right, then there's procedural breach. You have the right to administrative review and even judicial review, depending on the circumstance. So we are looking at when your visa is cancelled or you enter you arrive at the airport and they question you and you are not convinced. You are already in the UK but without a visa or leave, and you are stopped and questioned and put away. Or you are in the UK, you have a visa, but your visa is investigated further and they conclude that it wasn't issued properly or validly. And those reasons could be given to you. However, where there is intention to remove you, you have to be detained. And between the time of detention and your removal, it should be straightforward and swift, so that there's going to be passage of time. Then we conclude that the Secretary of State is not sure that your removal is necessary. And at that point, your removal will be questioned, or your detention will be questioned.
So then, the person that's detained, human rights reasons and the rest of it, can have access to a lawyer, can't they?
Yes, the person will have access to a lawyer, and the lawyer will then intervene on behalf of the client to say that we are seeking bail for our client on the basis that there has been administrative error or breach. And so our client is going to seek administrative review. If the visa is cancelled and this person is joining a husband, then there's Article 8 implication. What could be the reason why the Secretary of State will be preventing somebody from joining a family? Then we have to look into it. Then we'll address it. So administrative review will come in, and even to the point where it has to go to court for judicial review, or it has to happen. Remember, judicial review comes in because this is administrative error. And if the government agent has not followed its due process to do the right thing, and they are still not willing to change or amend their action, then it has to be looked into by the court.
All right. Then, finally, maybe from experience, what normally happens? Do the Home Office oftentimes make mistakes, or they may not have a reason to do that, except that procedurally they will have to follow and be sure that the person who is coming into the country is the right person and was given the right permission to do so?
Yes, they have the right by way of controlling illegal migration to ensure that those who come in are the right people who ought to be in the UK. So whether you were given the visa to come in, it's not the point. The point is that you are screened at the airport. Some people go through lengthy interview before they are cleared. Some people straightforward, but it's case by case. It doesn't really matter. Once they suspect that your entry clearance was obtained by falsehood or false representation, because the information you provided and the answers you are given at the point where they wanted to verify at odds, then you'll be asked to wait for further investigation. And if they feel that they have to remove you, you will. But the lawyer, what the lawyer will do will be to intervene and to put them on notice that they have their client's authority to act. And therefore, we have received certain papers, but not all of them. So they have to give us the papers based on which they have taken the action. Again, the person, the client, or the individual will have to be released on bail, and that's immigration bail. So once the person is released temporarily on bail, because if you are not going to be detained, they have to be released. If they are being released with the view for further investigation, then that's a bail. But your freedom is still not intact.
Okay.
Now, depending on the circumstance, your visa may not be cancelled, or it may be cancelled at the airport. If it is cancelled at the airport, then the idea is for the lawyer to fight it so that it is reinstated, having gone through the process. Between the time it is cancelled up to the final point, you usually be given, if it were to go to judicial review, 90 days to go through the process. So you go through admin review, they may come back to say the decision is maintained. Then you have to file what we call Section 120 representation to say that because of X and Y reasons, the client must be allowed to remain in the UK. Then it has to go to court, that's the judicial review process, citing your grounds or reasons why the matter is still, the action is inappropriate, and therefore the court of law should look into it. And once that goes through, it is up to the court to make the decision. If the court concludes that there was error on the part of the Secretary of State, then the visa will be reinstated.
Okay. Well, folks, if you just joined us, we have just gone through our nugget, and that's the bit Lawyer Charles Asma was explaining. Immigration detention is a practice of holding people who are subject to immigration control in custody while they wait for permission to enter or before they are deported or removed from the country. It is an administrative process, not a criminal procedure. But once the reason for the detention is ceased, the detainee should be released. And as I asked, definitely you will have access to a lawyer, and they will intervene on your behalf, at least to get you bail for further investigations to continue. This is the Community and the Law, brought to you by BWF Solicitors, our trusted partners when it comes to the law. Now, next week, we're going to look at a topic for today, very interesting one. If you are here as a skilled migrant, how do you meet the genuineness requirement? Genuineness requirement as a test. And if you are not able to meet that, what are the consequences? We'll be delving into that discussion right after this break.
This is our world. Here we are in our community. There are the laws. There are the regulations. We have BWF Solicitors. BWF Solicitors, experts in all aspects of the law, family law, civil litigation, all immigration and nationality issues, representation in court, marriage and divorce. We pride ourselves to give you excellent legal services and follow through till we get you the right result and decisions. That is our mutual satisfaction. We have a team of excellent qualified solicitors and support team to help you every step of the way. Our senior partner, with over 30 years of unbroken service to the community, is a member of the Family Law Panel and has advised several lawyers and institutions in many legal matters. He is qualified to practice both in the UK and in Ghana. Come to us. Speak to us. Let us represent you. We are your trusted community partners when it comes to the law. Locate us on the 4th floor of the Anna House, 214-218 High Road at Seven Sisters in North London. N15 4NP. Nearest train station, Victoria Line to Seven Sisters Station, exit number 2. We are open for all consultations from Monday to Friday, 9:30 a.m. to 6 p.m. Weekends by appointment only. Call us now on 0208 493 7340 or 077 127 61884. BWF Solicitors, your trusted legal partner.
Well. Thank you very much. And I know you're so eager to join us as we delve into the discussion. We're talking about the genuineness of the requirements you need to meet. Well, what are you asked to provide? What test are you supposed to go through? As a skilled worker, where do you seek help when you are bogged down with some of the challenges? This is what I'm inviting you to come with me as we go into the discussion and we enter the premises of BWF Solicitors whilst Lawyer Charles Asma, well, he is ready to lead us into the discussion. Lawyer Asma, good afternoon once again, and thank you very much for your time. I know it's a very busy weekend for everybody, especially you guys work all over. Sometimes I look at your shadows and I'm like, well, I'm not able to cope, but you are able to cope. Thank you for that. How is everything going on at work, sir?
Oh, yes. By God's grace, we are doing well, making the community happier and bringing good tidings the best way we can to people who would ordinarily not be able to enjoy freedom from immigration control.
All right. Well, talking about immigration control, everybody that's migrated from one country into the UK is subject to some of these controls, whether you put in an application, whether your application is pending and you're waiting for a response, and all the other bits. Now, we're talking about the skilled migrant route. For purposes of somebody who may not have a good understanding of that, what route is that?
Right. So the UK is a progressive nation and always seeks to advance its economic and sociocultural development by way of bringing new people, creating opportunities, not for the individuals themselves, but for the community, for the country. So where there is the need to bring in talents and skills, the government will take steps to open up.
Okay.
So before pandemic and after pandemic, there have been lots of opportunities for people to come in to support the development of the country. Now, a skilled worker is an individual who has some level of skill that the UK needs
Okay.
in particular sector of the economy. It could be healthcare, health sector, IT sector, educational sector, what have you. For the purposes of this conversation, we'll limit it to the health sector.
Okay.
So you know that post-pandemic strategies the government of the UK introduced is to ensure that people who are skilled from across the globe are given opportunity to come to the UK to support the health and care delivery agenda of the country. So what the government has done is that all those employers who are delivering such activities, healthcare, and health and care activities, have the opportunity to go abroad and hire.
Okay.
So the key thing is going abroad to hire. What it means is that they put up the advert and individuals from abroad can also apply. So it's not limited to individuals who are only in the UK, but also globally, because it's a global talent approach.
Right.
What it means is that if the person qualifies and is able to go through the selection process of the employer and is selected and offered a job, they will be given a sponsorship to come into the UK and work for that employer.
Okay.
We call it Tier 2 General.
Okay.
That Tier 2 General visa will give you opportunity to work for that particular employer. Call it working visa for simplicity.
Okay.
So you have working visa to work for a specific employer because that employer has seen the skill you have and hired you.
So it means that if they employ you, you can't work for any other person because it is you they need.
Exactly. Employer specific because you have been hired for the need of that employer, not other employers. However, for the purposes of the skill delivery agenda, health and care delivery agenda, what the government has done is that because there may be other employers needing support, even if you come in to work for one employer, you can go further to work for another employer within the same care industry, at least 20 hours. And even now, they say by end of the month, up to end of August or 27th of August, you can do unlimited. But because the month is ending gradually, we say that you can do 20 hours for the next employer. However, within the specific industry that you came into.
Okay.
So that's the condition.
Right.
So what it also means is that once the person comes in with this, it's a settlement route, and therefore the person will come in and stay for the period of the sponsorship. If it's up to 5 years and you have still remained with the employer, Then you qualify for indefinite leave to remain, settlement.
So
in
when,
your
having
sixth
spent
year.
5 years on that particular permit,
Yes,
you qualify to remain in the UK indefinitely.
indefinitely. So you have to then apply for indefinite leave to remain. And that's why we say this is a this is a settlement route, because once you are able to go through the process, you can qualify to remain.
Lawyer, for purposes of clarity, if you say for our discussion, we're talking about the healthcare route or the health sector. So does it mean that any occupation, any shortage occupation on that skilled worker scheme leads to settlement?
Yes. So there are, and each one you have to check the conditions, because some may come temporarily to help. That one will not lead to settlement.
Okay.
So there are some that lead to settlement and others that do not lead to settlement. There are some that allows you to come with your family, direct family, spouses and children. Others do not allow you to come in with direct family, spouses and children. But we know that generally with the skill, most of the skilled migrant program occupations allow you to come in with your spouse, or for your spouse to join you and your children to also join you.
All right. Well, if you just joined us, we're looking at the skilled worker route, and Laura has explained that there's a cohort that allows you to come in, and the caveat he just mentioned was that check whether it allows you to stay for a longer period, or you can bring your immediate family to join you whilst you are on that permit to work here in the UK. Now, genuineness is a word that I know the Home Office is so much in love with. They will want to make sure that whoever comes in to settle or migrate to the UK for any period of time is a genuine person, and the person says, I am A, and you are genuinely A or B. Now, the genuineness test is what I want us to look at again when it comes to the skilled migrant route. Do people do fraudulent representations? Let me put it that way.
I don't think so. However, everything is possible in life. It's up to the individual to prove that they have met the requirements.
Okay.
Prior to July 2023, you didn't have to show or meet genuine requirement test. And I'll explain what genuineness requirement is all about.
Yeah.
After 17th of July, we've had new changes. And one of them is that
2023.
2023
Okay.
have been massive changes, and that includes this conversation.
Okay.
Now, there are two aspects that we'll be looking at in terms of the genuineness requirement. One for the main applicant and the other for the dependent.
Okay.
Prior to the new rules, if you are the main applicant, all you needed to show was your contract, which is in the form of sponsorship certificate, what we call COS, certificate of sponsorship.
Sponsorship. Okay.
But that details the fact that you've been employed for the period, amount, and everything. That's your contract of employment with the employer.
Employer. Okay.
But the question is it true that you are coming to work as presented?
Okay.
So from July 2023, and it's the 17th of July, you have to now prove that you intend to do that job. And you intending to do that job means you must have an understanding of the job and the fact that you actually got the job and the fact that you know what the job entails.
Okay.
So you can see that to show that it is true that I'm coming to do the job, you must be aware and have an appreciation of, well, you went through the process to get it. So that's for the main applicant. So what is there for the person to show to prove that they have met the genuineness requirement test? We'll come to that. And we have one for the applicant dependent. And here we are looking at the spouse. The children angle is mainly to do with sole responsibility and also compelling and serious circumstances, either of them. But for the spouse, you have to prove your genuine requirement will not be whether the job will be performed by your spouse or not, but the fact that you are the spouse.
So you have to prove that you are the spouse.
Yes, and the fact that you are in a genuine and subsisting relationship. So you can see that a lot of the tests under Appendix FM have been imported or transposed into Appendix Skilled Worker.
Okay.
So they are trying to marry the two.
That's right.
Now, what do we mean by genuineness? For simplicity, we are saying that truth or truthfulness. So what is the truthfulness test for the applicant? The applicant must show that they went through the process to get a job. But if you didn't go through the process to get a job, you have just been given the job, then there's no way you understand the job. Then the question would be, is it true that you're actually coming to do this job?
Yeah.
Because you don't even know how you got it.
You may not have a good understanding of the job. You haven't shown how you got the job. So then it presupposes that you don't even know the job.
And then if you don't,
you can't do that job.
And then it concludes possibly that you do not intend to do the job. So what do I have to show to meet that test? One, yes, you have the certificate of sponsorship, but prior to that, you went through the process because you have to make a direct application to the employer. So it's within their right to ask for evidence of applying for the job.
Okay.
The next, once you've applied for the job, there will be acknowledgement or response. So where is the response? Where is the evidence that you were invited to attend an interview? How was the interview conducted? What was the response after the interview from the employer to you?
Okay.
And what was the next stage? And how were you offered the job? So all this will be documentary. So you have to have evidence. WhatsApp, text messages, or emails. For these days, because of IT and advancement in technology, most employers will carry out these things via modern technology. And WhatsApp is one, Zoom. You may not have evidence that the interview was carried out via Zoom.
Very interesting, though naive question. Is WhatsApp accepted in court?
Yes.
Okay.
Because what is accepted in court is evidence. And if the WhatsApp suggests that the employer sent me a message saying, congratulations for having successfully gone through the interview, we will send you the rest of the information later.
There's evidence.
There's evidence.
Okay.
So that is acceptable evidence in court. And that is why people, to show their genuine relationship and all that, they use WhatsApp communication to tell the court that, yes, look at the communication that have been taking place. Now, so we've gone through the stages. And again, we are looking at the fact that the person has an understanding of the job. So what is your experience in this job? Because you cannot apply to do a job in the UK from abroad, or apply from abroad to come and work in the UK in this sector if you don't have a level of experience.
Yeah.
So your CV must show that you have some level of experience. And even, of course, you went through interview, and per your experience, you are selected. So if the immigration officer wants to confirm that, they can ask you a question about the job. Have you done this work before? Where did you work? What does the work entail? So imagine you come in and you are asked, so what does your job entail? You have no clue.
You start scratching your head.
Then you do not genuinely have the desire to work or do that job. But you don't even know what a job is about. So that is that bit. So how do I prove? You should be able to understand, because you've gone through interview, and I'm sure you've passed the interview. That's why
they've
you've been given all the things you need. Your job description tells you what the job is about, and all the things that came with the advert, which you applied and all that. And therefore, you should understand that this is what the job entails. Per your own experience of doing that job, you should be able to express yourself. So if they're asking you about safeguarding matters to do with the job, you should be able to express yourself to an extent, and so on and so forth. So if you have no clue, then it will leave the third party, in this case, the officer interviewing you or trying to find out about the genuineness of your coming to the UK to work, be open to doubt you that you
Okay.
intend to.
Okay. Now, having gone through this, you have your documentary proof, you have every evidence, and obviously on the test there might be a criteria that you need to take of X, Y, Z, Z, and all that. Where does the test take place? Is it just on paper, or like we're looking at this detention at the airport? Is that where it takes place?
It can take place at any time. Remember, within the immigration rules, there is evidential flexibility rule that states that if the caseworker or the entry clearance officer is in doubt, they should invite the person for clarification, and that's the interview. So if you are a skilled worker, migrant, and you applied and they want to actually find out to test that genuineness requirement, they can invite you to attend interview before the visa is considered.
Okay.
But because of volume of work and resource constraint and all that, that aspect is not really done. Therefore, when you arrive at the airport in the UK, that test can be conducted, or that
At the
verification check
airport.
can take place. So it's up to you to express yourself to confirm that what you said in your visa application, what has been said on your certificate of sponsorship and your employer's letter, confirm that indeed you have intention to do the job and not coming to do something else.
Right. So I have been able to answer a few questions, or probably when I got to the airport, the entry clearance officer didn't see it fit to even question me. Can that test and the proof of whether I'm a genuine person happen later on in the course of my work?
Right. Once you have arrived and started working, the presumption is that the entry of the immigration officer deemed it fit to clear you. So you've entered, you've been cleared. Then you have to work for that employer, you are with your employer and working. Now, before that, we are saying that before you enter, this can happen.
Okay.
So if it happens, you should be able to show. Either you show it before the visa is issued, or you show it before you enter the UK. If I say enter the UK, I don't mean entering the airport. Because entering the airport is not entering the UK. You've entered the UK when you actually go through immigration and you leave the airport, or you leave the immigration
Okay.
point. Then, yeah, you've entered the UK. Now, let's go to the other side, where the spouse will also have to prove genuineness. And here we are looking at genuineness of the relationship,
Okay.
similar to what we have under other immigration appendix provisions. Now, they have introduced something
Okay.
that you have to prove that you have lived with your spouse for 2 years or less. So they will ask you, have you lived with your spouse for 2 years? It wasn't the case, but it's now the case. So if you say yes, requirement will be that provide 2 documents to prove that you've lived together for 2 years.
Live together at the same address.
Live together for 2 years. Because you say that you live with your husband or wife. And if you are living together, what do you think? In terms of address?
Well, in terms of address, yes.
Yes.
I know of people who are in subsisting relationships, but they don't live at the same place in Ghana, for instance.
Then they are not spouses. They are just girlfriends and boyfriends.
But if you say subsistent relationship,
What it means is that you live with your spouse. And remember, the person says, I have married the applicant.
okay,
So I am the wife or husband. So you can't say that your husband lives elsewhere and you live elsewhere. Then a marriage is really not subsisting. It's not it doesn't have life of marriage.
Okay.
So marriage is one that both couples are living together, living their life together, and appear to do things in common.
Okay.
How do we know that they are living together? They share the same address. And some may even have joint activities.
Activities. Okay.
So either joint activity is not compulsory, but living together, though not compulsory, is commonsensical.
Okay. Okay.
So
I get
that bit. Therefore, if you are a spouse and you are asked to prove that this is it, for now, you have to show. If you are living together, it may be that you have both rented and you are living together. So tenancy agreement may bear both names.
it. Okay.
You are living together, your bank statement potentially may bear the same address. Somebody may say, well, I live in my family home. We don't rent it. What the law is saying that provide two pieces of evidence at least to show that you live with your husband or you are in a genuine relationship. It's not a matter of pictures, because picture is not a document per se. You are proving it, so that's supplementary. But things like official document, letters from hospital, if you have some reviews, medical reviews, and letters were written to you, shows that this is the address, the other party to this is the address are the same, then presumption is that you live together. You have insurance policies together, be it life or whatever. If it's a life insurance policy, the spouse takes the insurance policy, but the beneficiary is the other spouse.
Okay.
So if I take insurance policy, life insurance policy, because it is life, my name is the policy holder, but the beneficiary is my wife. The wife also takes one. The wife's name is the policy holder, but I am the beneficiary on that. And that presupposes that, yes. So these are things that you need to be able to show that you are in a genuine and subsisting relationship with your spouse, the skilled worker, migrant. And doesn't end there. Once you also arrive at the airport in the UK, this can also be verified by way of questioning.
Question. Okay. Well, then I think the third category probably is the children. You talk about dependence. In the African society, maybe I use a case study of Ghana. I have my children, two or three of them. I have my nephew and niece that I take care of, and generally everybody knows about that. In this situation, is it just my blood children or people who depend on me that I can bring together with me to come on a skilled migrant visa?
So the law says that having been granted entry clearance to come in as a skilled worker migrant, you can bring your spouse, who is a spouse, by marriage or by cohabitation 2 years. So even if you are not married, but you are in a durable relationship or partnership,
And you live together at
that
the
is
same address?
akin to marriage. Then you prove that that is so, the genuineness test. Who then is a child? Your child is your child by birth or adoption, legal adoption.
Okay.
So if the person is not your biological child, then you have to show that the person has become your legal child. That's adoption. And adoption, you have to show court order confirming adoption for
Okay.
you.
Okay.
Otherwise, this child must be your biological child.
All right.
But the question will be, is the child for the applicant or the applicant's spouse? So is it the first level child or second level child? Second level child will be the stepchild. But the law allows for stepchildren or the main.
So you can prove that these are my stepchildren, and you can prove with documentary evidence that these are children dependent on you, and legally they are children.
Yes. So with children, it's not about dependency. It's about the fact that they are your children. If this person is my child, then dependency is obvious. Because a parent is a parent when they take care of their child or children.
Okay.
So I don't have to show that I take care of my children. Suffice to prove that this is my child and they live with me.
Okay.
But what the law then says is that what shows that you play the main role or the sole responsibility role in the child's life. So the question will be, are you both parents, or one of you is?
Is a parent.
That's why I said first level or second level. If you are both first level parents, then you are both parents of this child. You don't have to show sole responsibility because we are both parents. You have to show consent that you are both happy for the child to join you in the UK. If the other one is already here, you both do a letter signed to show that we are both happy for our child to join us. If the child is for one of you, then the owner, the sole parent must prove that they have sole responsibility because the child belongs to somebody else.
Okay. Well,
But let me put in this.
Can I just quickly take a break, and when I come back, we get into that further discussion. Is a community and the law alive? I'll be right back.
This is our world. Here we are in our community. There are the laws. There are the regulations. We have BWF Solicitors. BWF Solicitors, experts in all aspects of the law, family law, civil litigation, all immigration and nationality issues, representation in court, marriage and divorce. We pride ourselves to give you excellent legal services and follow through till we get you the right result and decisions. That is our mutual satisfaction. We have a team of excellent qualified solicitors and support team to help you every step of the way. Our senior partner, with over 30 years of unbroken service to the community, is a member of the Family Law Panel and has advised several lawyers and institutions in many legal matters. He is qualified to practice both in the UK and in Ghana. Come to us. Speak to us. Let us represent you. We are your trusted community partners when it comes to the law. Locate us on the 4th floor of the Anna House, 214 to 218 High Road at Seven Sisters in North London, N15 4NP. Nearest train station, Victoria Line to Seven Sisters Station, exit number 2. We are open for all consultations from Monday to Friday, 9:30 a.m. to 6 p.m. Weekends by appointment only. Call us now on 0208 493 7340 or 077 127 61884. BWF Solicitors, your trusted legal partner. Our private client services team is recognized for providing clear and practical legal advice to our clients in the United Kingdom and Ghana. Expert help with will writing, probate or estate administration. Our will writers and probate lawyers can act for you to obtain grant of probate and carry out estate administration on your behalf. The probate takes place after the named is responsible lawyers offer strategic and practical solutions to the issues which clients face, whether it's in relation to succession planning, will preparation, probate and the administration of estates, immigration and visas, contentious family or probate disputes, administering estates often with inheritance cross-border issues, international trust advice including residence, domicile issues, wealth preservation, a fast, efficient service from SRA-regulated professionals, transparent pricing. BWF Solicitors, let us take care of probate.
Welcome back. Thank you very much for sticking and staying. We're live on BW TV. Lawyer Charles Asma from BWF Solicitors is our resource person, and we're looking at passing the genuineness test when it comes to the skilled migrant route for immigration. If you have any question, just put it in the comment section on Facebook and YouTube. We're live on Facebook and YouTube. And also you can text it to 073992684 sorry, 07399208468. Our WhatsApp number is 07950422780. You can call in, and if you have a question to put to Lawyer Charles Asma, it may be on any other legal topic, but what we're looking at now is the skilled migrant route. You have any question, you can just put that across. You can call in on 073-99208-468 or send a voice note to 0795042278. How do I meet the genuineness requirement test as a skilled worker migrant? That's what we are discussing. On the platform, we have so many people coming in. Keep on liking the page and click on the notification button so that when we put any content on, you will have the benefit of knowing and seeing it and also sharing with the people. Margaret do Mensa, thank you for joining us. Frankie Boy Harrison, you are also with us. We have Tilly Duma, who was the very first person to log on. Thank you, Tilly. Rebecca Mwako, Dokasadum, Sarah Pinzo, Ohio, Isaac. We have Patience Nanayao Asaribidiako, Ademonunkum is online. Sandra Fraser, thank you so very much. And of course, all the other people that are on, congratulations to all of you for coming on and also catching my attention. Okay. And also, I want to say thank you so very much for sharing the page and passing your comments. Well, to enlarge us, I come back. There was a point you were making. Let's pick it up from there. We're talking about genuineness, talking about children, and also making sure that we show social responsibility. Can we pick it up from there?
Yes. So the point I was going to add is this. So the application checklist will require you to provide consent as a parent if the child is coming to join you. There are two aspects. When the consent is to be provided by both parents, because both parents are the actual parents of this child, and one is joining the other who is already in the UK with the child, it's obvious. Consent is straightforward, isn't it? Because you are both. But if you say you are solely responsible for the child, that means the other parent is not. The other parent is somewhere else. And maybe you have said that you don't even know where the other parent is. At this stage, how many people will provide consent? Will the other parent be able to provide consent?
No, because they're not available, yeah.
They are not available, and you have said that they are not available. So if they are now able to provide consent, then the conclusion is that, hallelujah, there's somebody available to help the child. So they don't even have to come.
So it's a bit technical, and it demands that you apply common sense, so to speak. Because if you say I am solely responsible, then you're solely responsible. Nobody else should come in.
Yes, because consent is also a decision.
Okay.
What you are saying is that I need permission from the other person. And most people will say, I agree that my child goes to join the mother or the father or travels abroad. But the mother or the father making the application for the child potentially has said that the other parent is nowhere to be found or is irresponsible. So they are solely responsible. Because the other one is irresponsible.
That's right.
Or they are dead, or they can't be found. So if they are so irresponsible, having now become responsible and to show consent, then the child can come.
Because there's
But they have a responsible
parent
somewhere
to take care of them.
So you cannot provide consent from the other party or parent if you claim that you are solely responsible for the parent. So in that case, there cannot be any consent.
Okay.
So consent is not compulsory if it doesn't apply in the circumstance.
Right.
If it applies, you must.
You must.
If it doesn't apply, you don't have to because it doesn't apply.
Okay. Now, this test, once passed at a point, either prior to entering or at the point of entry, once passed, is that the end of the story? Or you could be asked to prove it again?
Other things being, once you entered the UK and started working, you don't have to provided you are compliant and doing what you came here to do. But if you came here and ended up doing something else, then it appears that your intention is different from what you claim you were coming here for, or what you had for coming here.
Okay.
And let me check in this. There's somebody who contacted about 2 weeks ago. The lawyer, I have a problem. What is it? I work for my main employer 40 hours, because that's my contractual hours. I also have a right to work for another employer, and therefore when I went to this employer, they gave me more job to do. What has now happened is that they said, well, how they found out, I don't know, he says, but they now say that I'm doing more than the hours required, and so I have breached my terms of the entry or employment.
Okay.
Because the rules are that you do the hours with the main employer and 20 with another employer within the industry, up to unlimited hours up to 27th of August. I think this person was, even before before the rules came in, was doing unlimited hours because the hours were available. Forgetting that you are supposed to do up to 20 extra. So he said, now my visa, they are threatening that they're going to cancel my visa. The immigration people have contacted me on all that. So he's here to make contact again with us. But this is one example where then the question here is, okay, you are working for this employer, but it appears that you're also doing something else.
Okay. Does the Home Office really, from time to time, check on whether people who have come in are doing what they say they are doing?
See, when employers are applying for the license to sponsor migrants, one of the conditions is that show that you have a monitoring system to monitor the staff now and in future when you have more staff.
Okay.
And people go through the process, tick the boxes because they are able to meet that condition.
So I have a 3-year contract. The 3rd year has expired, and I have the opportunity of the same employer renewing it for me. At the point of renewal, do I have to pass this genuineness test again?
You're already in the UK. So it's not a case that somebody at the airport will question you. You are renewing your visa, having renewed your contract.
That's right.
So then you go to the Secretary of State or Home Office to apply for extension of visa. But in terms of the process, it will start again. Employer's name and blah, 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 and blah, blah, blah. You go through the checklist. Some of them, because you've had it already, it may be the case that you don't have to show it again because the records will be available. I still have to show that you have certificate of sponsorship for the second half.
Okay. If you just joined us, you can call in 0739920848 or send a text or WhatsApp to our line 07950422780. A resource person, Lawyer Charles Asma from BWF Solicitors, is here to address that. On the platform, I have Thanks JFK. That says that a care company has issued a COS, that is Certificate of Sponsorship, to my dependent, and she's yet to submit her documents to the Home Office next week, God willing. Are there any questions she needs to know before, since they keep changing their rules governing the country with respect to jobs? Lawyer.
Because they have already submitted the application, the checklist will tell them what they have to provide.
Okay.
They have to submit the document that they have asked for. One of them may be that they have to show that it's a dependent, show that you lived or have lived with your dependent for 2 years.
Okay.
Depending on how long they've lived for.
Okay. Another one here says from Mami Ajiman. We have it on the platform. It says, my sister is doing her application in Ghana, but she has 2 kids. So they are going to do a DNA test because she doesn't have enough money for the extra cost. Does that have to happen?
Which extra cost?
Mami Ajimai, you didn't tell us, but if you could provide some clarification. But all she's saying is the sister is doing application in Ghana. She has two kids. They are going to do a DNA test because she doesn't have enough money for the extra cost. I don't know what extra cost there are.
So we don't know the type of application, and we don't know why they are doing the DNA. Because if you are doing DNA because you will save money, we don't do DNA to save money somewhere. We do DNA to prove paternity or maternity of the child.
Okay.
So we need more information to assist with.
Okay. So if you could help us with further information, Mami, that would be very useful. Another one here says, I'll be going for a skilled worker visa interview at the Home Office tomorrow. Do they work on Sundays? Because since it's Saturday, probably talking about Monday. Anyway, what are the documents I need to present? I am already in the UK and my sponsor never issued any appointment letter. Should I contact my employer for it?
So this person is in the UK,
Yes,
switching, I suppose,
I suspect so.
and they've been invited to attend an interview. So so if this information is anything to go by, then it tells us that they've started inviting people to confirm the genuineness requirement.
Okay.
That indeed this is a job for them that they are going to do. So why would they invite you to attend interview as a skilled worker migrant? They want to be sure that the job is a job, and two, whether you are going to do the job.
Okay.
What document? I'm sure it's not about the document you have to present. It's about you confirming. So there will be questions they will ask you. But suffice to say that if you have been issued with certificate of sponsorship, then that is important document to have. They're not going to ask you to provide COS, and that will be it. They are going to test you on whether you have genuine intention to work for that employer and whether the job itself is genuine, whether there's actually job for you.
Okay.
So they've started doing that from what our friend has said.
For the genuineness test, is it something on the person who is coming to work, or there's a genuineness test on the part of the employer as well?
So this is visa application, and therefore it is the applicant's duty to prove that they have genuine intention to work or to do the job they claim they are going to do. The employer has already proven genuineness, met the genuineness requirement as part of the license application. So they have met the requirement and been issued with license to employ. And they've also gone through the process to have the COS issued. That means they've been able to prove that the job is there. It is up to you, the employee or prospective employee, to show that you have intention to do the job that you claim you are going to do.
People have, or anything happens, um, I've come in. The employer initially, in the first few months, was able to provide me with, as we normally say here, shifts. The job was there. But for some reason, demand has gone down, and in the care home, there are no clients for me to take care of. So then I don't really have a job. Do I have the right to move to another um, employer to work whilst I'm still on the previous contract and the certificate of sponsorship?
So once you arrive and are working for your employer, you are put on a PAYE, payroll. The only proof there is to show that you are actually working is the payroll process. So if at the end of the month, you have your evidence to show that you have worked and been paid, then who is anybody to question that you haven't worked? That is first point.
Okay.
But if the job is not there and you are not working, then you can't prove that you are working because you have nothing to show. If it's a case that you are not working for the employer, then it appears that there has been change in circumstances. And that change is that there's no more job. And if there's no more job, then the reason has changed, and therefore you can continue.
So in that case, do I have to
Then you
go
have
back?
to, no, you have to switch to another employer
Okay.
to start the process to get reintegrated.
So in between finding a new employer, does the person become illegal?
You still have your, even if the existing employer tells the Secretary of State that circumstances have changed and therefore this is the case, they will inform the applicant or the migrant to find alternative employer. So you'll be given a period to do that, at least 60 days to find alternative employer.
What if after the 60 days I've been found
You
illegal?
have been given a chance to look for, and that is flexibility. If after flexibility period you still don't have, already you have been put on notice that this is going to happen, and whatever there is that will happen, and it is the case that they will cancel your leave.
It doesn't sit down very well with me, actually.
It's the reality.
Wow. I hope nobody falls into that because, as Lawyer said, it's the reality.
So you just have, if it's the case, you find an alternative employer, because there are alternative employers willing to migrate you, so to speak.
Okay. So then, does it have to be a new certificate of sponsorship?
That's the alternative employer. So the alternative employer will have to then sponsor you. You have to do a new visa application using the new COS.
Do you have to go back to your home country?
No, you are switching.
You're just switching. How easy is it to switch?
So easy if your documents are available.
Okay. Well, I believe that if you find any challenges in your switching or have any questions and concerns you want addressed, I will want to advise you that confidently go to BWF Solicitors, 214-2218, Tottenham High Road, Seven Sisters, North London, 0208 493 7340 is their telephone number. They work Monday to Friday between 9:30 in the morning and 6 p.m. in the evening. There is an emergency number you can call any time of the day, 077 127 61884. 077 127 61884. BWF Solicitors has over 30 years of rich legal experience to support you. Now, when it comes to any updates, when we're talking about the law here in the UK, BWF Solicitors is unrivaled. Speak to them, talk to them. They understand your language, they understand your situation, and they invite you to come and bring everything to them and they will solve it for you. BWF Solicitors, our trusted partners. We'll take a break and we'll come back to continue with our discussion on the program, the community, and the law.
This is our world. Here we are in our community. There are the laws. There are the regulations. We have BWF Solicitors. BWF Solicitors, experts in all aspects of the law, family law, civil litigation, all immigration and nationality issues, representation in court, marriage and divorce. We pride ourselves to give you excellent legal services and follow through till we get you the right result and decisions. That is our mutual satisfaction. We have a team of excellent qualified solicitors and support team to help you every step of the way. Our senior partner, with over 30 years of unbroken service to the community, is a member of the Family Law Panel and has advised several lawyers and institutions in many legal matters. He is qualified to practice both in the UK and in Ghana. Come to us. Speak to us. Let us represent you. We are your trusted community partners when it comes to the law. Locate us on the 4th floor of the Anna House, 214-218 High Road at Seven Sisters in North London. N15 4NP. Nearest train station, Victoria Line to Seven Sisters Station, exit number 2. We are open for all consultations from Monday to Friday, 9:30 a.m. to 6 p.m. Weekends by appointment only. Call us now on 0208 493 7340 or 077 127 61884. BWF Solicitors, your trusted legal partner.
Welcome to City of Favor Estates, developed by Sarenano and Sons Company Limited, located in Tema Community 25 extension off the Tema Aplau Road. City of Favor Estate offers 2, 3, and 4 ensuite bedrooms on 118, 138, and 178 to 190 square meter lands, respectively, to give you the needed space. Our gated estate homes are designed with you in mind and have all the necessary amenities located in a serene environment with security. You too can be a homeowner at a price that suits your budget with flexible payment terms. Choose City of Favor Estate for peace, comfort, and safety. Reach us on 0542 563 250 or 0243 235 518.
Our private client services team is recognized for providing clear and practical legal advice to our clients in the United Kingdom and Ghana. Expert help with will writing, probate, or estate administration. Our will writers and probate lawyers can act for you to obtain grant of probate and carry out estate administration on your behalf. The probate takes place after is responsible for Our lawyers offer strategic and practical solutions to the issues which clients face, whether it's in relation to succession planning, will preparation, probate and the administration of estates, immigration and visas, contentious family or probate disputes, administering estates often with inheritance cross-border issues, international trust advice including residence, domicile issues, wealth preservation, a fast, efficient service from SRA-regulated professionals, transparent pricing. BWF Solicitors. Let us take care of probate.
Okay, welcome back. Thank you very much for joining us. Now, you know what? Let me quickly go back to where we started and look at our nugget. Our nugget is talking about detention at the borders and the rights that anybody has have to be respected. I want to quickly read that, and yeah, I've got it here. It says that immigration detention is the practice of holding people who are subject to immigration control in custody while they wait for permission to enter before they are deported or removed from the country. This is an administrative process, not a criminal procedure. But once the reason for detention is ceased, the detainee should be released. Okay. Let's take this break and we'll be back.
This is our world. Here we are in our community. There are the laws. There are the regulations. We have BWF Solicitors. BWF Solicitors, experts in all aspects of the law, family law, civil litigation, all immigration and nationality issues, representation in court, marriage and divorce. We pride ourselves to give you excellent legal services and follow through till we get you the right result and decisions. That is our mutual satisfaction. We have a team of excellent qualified solicitors and support team to help you every step of the way. Our senior partner, with over 30 years of unbroken service to the community, is a member of the Family Law Panel and has advised several lawyers and institutions in many legal matters. He is qualified to practice both in the UK and speak. Let us represent you. We are your trusted community partners when it comes to the law. Locate us on the 4th floor of the Anna House, 214 to 218 High Road at Seven Sisters in North London, N15 4NP. Nearest train station, Victoria Line to Seven Sisters Station, exit number 2. We are open for all consultations from Monday to Friday, 9:30 a.m. to 6 p.m. Weekends by appointment only. Call us now on 0208 493 7340 or 077 127 61884. BWF Solicitors, your trusted legal partner.
Well, thank you. We sorted now. Let's move on. As I mentioned, I read the nugget specifically for the reason that I will be putting up a quiz on that. So look at it closely and carefully, so you'll be able to answer the question I'll pose. I want to quickly read that again. It says immigration detention is the practice of holding people who are subject to immigration control in custody while they wait for permission to enter or before they are deported or removed from the country. It is an administrative process, not a criminal procedure. But once the reason for detention has ceased, the detainee should be released. Now, this is Hardy Singh Principles, Lumba 2011, a UK Supreme Court 2012 case. And well, it's been in existence for a long time, so I believe that if you didn't know, I'm telling you again. But if you are detained at the airport, what I would advise you do is to ask them to give you the permission to contact a lawyer. And your sure number or short numbers, at least these two numbers should be handy. So keep it and you can give to your folks anywhere in the world. 0208 493 7340, 0208 493 7340, or 077 127 61884, 077 127 61884. That's the number or the numbers for BWF Solicitors, and you are sure that you will get representation. And at least if they're not able to do anything for you, they can get you bail so you can come home and continue with the case. So trust BWF Solicitors to do this for you. And right on the program, we are moving and picking the questions that you have put on the platform. Let me go over to the platform and pick this one from Mami. Mami, you sent in this one, and I think it's a follow-up. Let's see if we can pick it up again for you. It says that she doesn't have enough money to pay the money for potential DNA. The lady that was talking about the DNA. The application was for a certificate of sponsorship as a care home worker. Also, we were saying that the sister doesn't have money for a potential DNA test if they requested it from her when she comes with her case. In that case, what should she do? Because now she has to provide evidence or prove that the kids are her children.
So I don't know whether she's been asked to provide, but obviously if she's applying for the children, she will have to show that these are her children. And she has the birth certificate. Usually they will question the birth certificate, even though it's a wrong approach. So what people do to make it easier for themselves is to apply for a DNA and to get the report, because DNA becomes sacrosanct. Not everybody would want to go through the DNA process. And again, it's not compulsory, but it's necessary. Mm-hmm. So if it's necessary and will make your case easier, then you have to add that process to the budget you are putting in place for this project so that you do all the necessary things. It's not compulsory, but it's necessary.
Well, if you have the money, do it. Eunice says, I'm applying for skilled worker visa as a nurse from Ghana with my child, but I'm not in a relationship with the other parent who is also in Ghana. Do I need to prove sole responsibility or I need consent from the other parent? If I'm not solely responsible, what can I do? I think that was touched on, but this is a peculiar situation, and I think many people are in such.
What does he want to do? Bring a child?
Yes.
From the UK. What does he have in the UK?
This is applying for skilled worker visa as a nurse.
Okay. So applying as a nurse to come in, wants to come with a child. but the child is somebody else's child. So this person is a single parent.
Right.
He or she at the moment, the migrant. It says
Didn't
I
state.
am. Okay, but it doesn't matter. So want to come with a child. So responsibility is crucial because the person is saying that they live with a child alone and they are single parent. So responsibility is very, very, very crucial here. And we have already answered the second part of the question, is consent necessary? You don't need consent if you are solely responsible. For the other parent, you are saying you don't even know where he or she is. So you don't need consent from them. If they are providing consent, then the two of you are making the decision as to where the child lives or should live. If two of you are making this important decision, then all these important decisions are made by both of you, including this one. So they can say that the child has somebody else to live with, so you can go, let the child stay where they are. Because also in the best interest of the child to stay where they are, if they are okay where they are. That's the first thing we have to consider. So he or she will have to show that, yes, this is the child, and two, they are solely responsible. If they are not able to meet the sole responsibility test, it will be difficult. The other parent must not provide consent because they are not in the life of this child.
Okay. Now, this skilled migrant or skilled worker scheme, does it limit the number of dependents you can bring along with you?
The rules say that having been granted the COS and applying to come, you can come with your family. And here we are looking at your spouse and your children. It says your children. What it means is it depends on how many children you have, or your children.
Now, this question brings to mind, when on the other routes for under immigration rules, you'd have to prove financial meets the financial
Yes.
requirement, accommodation, and the rest of it. Do they come in here?
If the employer says that maintenance is covered for the migrant and dependents, then you don't have to.
Okay.
If the COS doesn't say that maintenance is covered for the migrant and the dependents, then you have to show.
Can I ask for that in my contract when I'm negotiating for?
Most employers will make that provision and will say yes, because they will say yes to the main applicant, the migrant. And because the question is phrased to cover the dependents as well, once they take yes, it covers all of them.
Do they necessarily have to pay for that
If
as part of my remuneration? So
pay for
um, it covers my spouse, my children. I would need accommodation for them. I would need to feed them, and because obviously it will be subject to no recourse to public funds, wouldn't it?
yes,
So do I have to earn enough to cater for those things?
all right. So if the employer says maintenance is covered, they have guaranteed
That they will
that
pay
you
for
don't
them?
have to prove
Okay.
whether they are paying for it or not. They have confirmed that it's covered for
Okay.
you and your
And they will
dependents
pay them. Okay.
who are coming or will be coming. So you don't have to worry about the maintenance. So you always have to check whether that box is ticked and it shows yes.
Okay. Well, a bit on the periphery, swaying a bit away from that discussion. But if I'm giving a 3-year contract, I come with my dependents, my wife, my children. Now, when I qualify for indefinite leave to remain, say I've stayed on that for 5 years, does it cover my dependents as well, or they will have to make a different application?
So dependents always tag along the applicant or
Okay.
the main person. So wherever the main person goes, dependents follow. So if the main person is going for extension, dependents will follow for extension. If the main person finishes and moving for indefinite, dependents follow her or him to indefinite level.
Okay. All right. But she says that he's had the worker, skilled worker visa scheme on healthcare, on the healthcare route or whatever it is going to be stopped. Is it true?
Everything in life is not permanent. It's also likely that this policy will end at a point. As I speak, today is 19th of August, 2023. There's no policy direction suggesting that a particular date this will end. But we know that at a point, because remember, it was introduced to fill a gap. If
Okay.
the gap is filled, then it's likely it will end once they've gotten what they want.
So at the moment, it's open ended, I
It's
guess.
open. We don't know. We know they still need people. So the government still has the open. There are tweaks here and there, changes here and there, but it's still running. And we don't know when they will think that it's enough. And it's likely at a point.
The healthcare route seems to be the most popular one, but the other ones, are they really happening? And
Yes, other ones are
is it the same set of conditions that we have for them?
So with the ones on the shortage list, they are on the occupation short list, but there are ranks. So the ones that are really, really crucial, those ones, let's call them a premium level. Healthcare is
Okay,
premium.
that's right.
Therefore, now you don't have to pay IHS.
Okay,
You only pay your visa fee, you don't have to pay IHS. And you have to show, and again, employers do not have to pay too much in terms of the wage threshold.
okay,
20,000, 21,000, 22,000, at least within that range. But when it comes to the other categories, if it's not within the premium level, then there are in other categories, could be IT, could be teaching, could be construction, could be other ones, you have to pay 27 plus
okay.
as an employer to the employee. So the salary range differs depending on the type of job we are dealing with.
The rates you are mentioning, are they the minimum that has to be paid?
Yes.
Okay, all right. So if an employer pays me less, can I report?
Then the employer has breached their condition. Then you cannot even hold that visa.
Okay,
For example, if your COS shows that you are going to be paid 18,000, meanwhile that condition on that list for that job is that it has to be 22 or whatever, then you won't be given the visa. Or one of them is that you got a job and the salary is at this level. Is it true on the COS? So they will assess. If it's not true, you'll be refused the visa. And the reason will be that your job is not, the salary of your job is not up to the threshold level.
okay. David says that can a visitor who applied for EUSS on grounds of a dependent from grandparents, can he apply for healthcare visa after he's been given a certificate of sponsorship, or would he have to return to Ghana to apply for the healthcare visa? So somebody applied and came in here on the grounds of EUSS dependent. Um, the person's found a job on the care worker route. Can the person switch in here or would have to go back to the country to apply?
I think yeah, I get what you are saying, but I also think maybe we'll check again that he came as a visitor and switched to UUSS.
Can a visitor who applied for EUSS on grounds of dependent from grandparent? So I am
So the
thinking
person
that
comes in as a
as a
visitor,
visitor.
switches to UUSS. Application is pending. They have certificate of application. They are
Okay.
waiting for a decision. They are not yet holding UUSS. So what they have is
Is
visitor.
a visitor's visa, right? So then they'll
You
have to
can't
go back.
switch with a visitor to this one.
So you have to go back to
If
the
you
home
want
country.
to do it, you have to do it from your home country, because you can't do it from within.
Would that affect the application for that EUSS dependent?
Well, if you have application pending and you leave, the application is withdrawn automatically.
Okay. 073-9920-8468. You can call us on that or send a text to 07950422780. Or you can call us via WhatsApp on the same number 079 50422780. Better still, leave the comment in the section below on Facebook, on YouTube as well. Now, listen, let's share the page. Let's invite people to enjoy this. This is free education when it comes to legal matters, and we're doing that courtesy of BWF Solicitors. They are our proud sponsors, and they're so gracious in helping us to find answers and solutions to our concerns and questions. Remember, they work Monday to Friday between 9:30 in the morning and 6 p.m. in the evening. Telephone number 0208 493 7340. 0208 493 7340. Now, viewers and people who have been following this program, BWF Solicitors has a tradition where every Christmas we do our quiz and we get people to win various prizes. Last year in 2022, December, what we did was to organize a quiz, and there was a return trip to Ghana, stay in a hotel, flights and hotel accommodation all catered for. And we did that quiz, and I am happy to announce that the winner is now ready to travel. Oh wow. I can't put the ticket and the details on the screen, but I'm happy to announce that this year, before Christmas and the next quiz competition, our winner is traveling to Ghana, and the ticket is here on the British Airways flight, hotel accommodation fully booked and paid for, and the person is going away to enjoy some holidays. I wish I was going myself to enjoy the sunshine. But well, we have sunshine here in the UK until at least the next few weeks. So whilst you go to Ghana, all the best. We wish you a safe journey, and congratulations to you as well. Foster Siama, your flight and everything is booked and you're ready to travel. Congratulations. So keep your fingers crossed. December, we shall be doing another round of that, and definitely BWF Solicitors will give you the chance to win another wonderful prize. BWF Solicitors are trusted partners when it comes to the law. Now, they do wills and handle your probates as well for you. If you are talking about marrying and also going through divorce and all the applications around it, please talk to BWF Solicitors. If you want to acquire property in Ghana or here in the UK and you want legal advice on that, talk to BWF Solicitors. And when it comes to immigration matters, your appeals, your initial applications, and all the information you need about applications, about immigration, and all the matters around it, please talk to BWF Solicitors. They are on this number 0208 493 7340. 0208 493 7340 077 127 6184. Very soon we shall be going to our quiz segment, and I would ask my producer to graciously ask us to look at our nugget again and see what is there, so you can get the answer so easily and quickly. It's knowledge I want you to have, and I believe that you have it as well. Immigration detention is the practice of holding people who are subject to immigration control in custody while they wait for permission to enter or before they are deported or removed from the country. It is an administrative process, not a criminal procedure, remember that. But once the reason for detention is ceased, the detainee should be released. Another thing I want to put across, this is something from one of the satisfied clients of BWF Solicitors, and Ms. Kata says that she's absolutely delighted to share her experience with the outstanding service she received. From start to finish, the team went above and beyond to make sure everything was done accurately. The attention to detail BWF Solicitors displayed was truly commendable. They took the time to understand the specific needs she had and tailored their service accordingly, resulting in flawless execution that left her impressed and brought success. And to BWF Solicitors, Uncle Charles, Ms. Kata says, God bless you for the good work you have done. That is a satisfied client, and I want you to be as satisfied as that. So send everything to BWF Solicitors. Well, it's about time we took our quiz, and let me ask you to test your knowledge. Let's see what happens. Diana Kate is an EU national who has been resident in the UK since 2005. She has both a permanent, since 2010, a permanent right of residence, and now on indefinite leave to remain. In 2022, she was convicted of possessing with intent to supply Class A drugs and sentenced to a 3-year jail term. As she's an EU national with permanent residence since 2010, there is a high threshold for the SSHD to meet before deporting her. On her release from prison, she was detained by the SSHD. What would that be, Aloy?
Sexual State for Home Department.
Home Department, thank you. However, her removal was several months away. She applied for immigration bail. In your view, can her bail application succeed? In my answers, probably I would have said she should have contacted BWF Solicitors. Anyway, let's look at the options we have. No, because she is a convicted criminal. Number 2 is a yes, because her removal is not imminent or it's not immediately going to happen. And 3, no, because she's a bad person. So let's look at the 3 options again. No, because she's a convicted criminal. Yes, because her removal is not imminent. And 3, no, because she is a bad person. So let's see what your answers will be. So put them in the comment section there. We'll pick them and put them on the screen for you. Diana Kate is a EU national who's been resident in the UK since 2005. She now holds permanent resident status. In 2022, she was convicted of possessing with intent to supply Class A drugs and sentenced to a 3-year jail term. As she is a EU national with permanent residence since 2010, there is a high threshold for the Secretary of State and for the Home Department, Secretary of State for the Home Department to meet before deporting her. On her release from prison, she was detained by the Secretary of State for Home Department. However, her removal was several months away. She applied for immigration bail. In your view, these are the questions. In your view, can her application succeed? Well, yes, because her removal is not imminent, that's number 2. No, because she's a convicted criminal, that's number 1. And the third one is no, because she's a bad person. What answers do you have? Let's see what you will bring. You can text that to 0739920848 or send a WhatsApp message to 0795042278. Let's see what you brought. Vivian says number 2. Okay. Who else? Tilly Duma says number 2. Number 2 says yes, because a removal is not imminent. David O2, number 2. Yes, because a removal is not imminent. Let's keep them coming, keep them coming, keep them coming before we ask lawyer to do that. I've got about 4 or 5 answers. Margaret Etumesa says number 2, because her removal is not imminent. It's not going to happen immediately. That's what it says. What about you? Bring your text. Bring your answer. Is it 1, 2, or 3? 1, 2, or 3? Which one? Okay. Adem Mununkum says number 1, no, because she is a convicted criminal. Nana Sapon says number 2. Number 2, yes, because her removal is not imminent. It's not going to happen immediately. That's what it means. Who else? Who else is bringing anything? Who else is bringing anything? Let's see how many we can take before we go over to lawyer to explain the question and also provide us with the answer. Let's see. 2 seems to be very popular. 2 seems to be very, very popular. I think so far only one person has come with number 1. Kofi Antubam says number 1. Kofi Antubam, did you say number 1? Okay. Rebecca Mwako says number 2. Let's keep going. Let's keep going. Keep them in the comment section below on Facebook and YouTube. Rebecca Mwako, yes, I've seen your number 2. Thank you very much. Who else? Who else? Let's see who else. Let's see who else. I've got just a minute and I will ask lawyer to help us with the answer. Who else? Let's see who has anything to send us. 0739920848, your text. And if it's on WhatsApp, 07950422780. Okay, now I think I will be allowed to go to lawyer to look at. Jones says number 2. Okay, now, lawyer.
Right. So we looked at the Hadel sign principle, and one of the threshold, or there are 2 key thresholds. One is that the removers should be sufficiently, there should be sufficient prospect.
Okay.
Sufficient prospect. What it means is that it should be possible, not maybe-ish. And the second test is that there should be high level of certainty that the person will be removed. It's similar to sufficient prospect. The sufficient is put into inverted commas. What it means is that sufficient depends on the circumstance. Because sufficient, in terms of time, are we looking at 1 month, 2 weeks, or what? So it should be reasonable. So if we say that a person is going to be removed within a month, then there's sufficient prospect. Within a few weeks, 3 weeks, it has to be a number. But when we say, well, the person will be removed, and we are doing the carrying out investigation, then you are not sure. Then the high-level threshold, which is high-level certainty, is not met. So this is somebody who is to be removed. The Secretary of State is still carrying out investigation. They are saying that the prospect is several months' worth away. Is it sufficient? No, potentially, because we don't even know how long. Several months could be next year, next 2 years. And therefore, it's clear that there's no certainty. And if you say that it shouldn't just be certainty, high-level certainty. And this one, there's no high-level certainty that this person will be removed. So if the person is not going to be removed because you don't know whether he will be removed or not, then why do you keep this person away? Remember, it's not a criminal procedure where you say that it's about public good. It's a procedural issue. And therefore, if your processes are not complete, you don't keep the person away. And therefore, this person has a chance because there's no imminent removal in this issue. So the answer is yes.
So the answer is number 2. Those of you who text in or keyed in number 2, you are right. And with that, I want to say congratulations to all that were able to bring in number 2. And congratulations to Kevin Asamoah, our friend who is traveling to Ghana to enjoy his prize. All expenses.
Is it Kevin or Foster?
Is it Foster? Hold on. Foster Siama. That's right. Foster Siama. Thank you
Kevin's
very
a
much.
regular friend.
Okay.
They didn't win on this occasion.
Foster Siama is going. And Foster, I have got your message here. Well, I wish I can come to the airport and say bye-bye to you and take pictures and show to people who also participated in that. Foster Siama, congratulations. Thank you very much. Your ticket is booked. All expenses have been paid. Your hotel is ready and waiting for you in Ghana. And you know what? Those of us who didn't win are also waiting patiently for December for another one. Maybe you will enjoy some barbecue along the line somewhere before December. Thank you very much. Well, lawyer, just before we round up, as usual, as tradition demands, you give us a brief summary of what you have led us to discuss this afternoon.
Thank you very much. Viewers and listeners, today we have looked at genuineness requirement within the skilled worker provisions. What the provision states is that if you are the applicant, you have to show that there is genuine intention that you are going to do the job for which you are making the application or for which you have been sponsored. What it means is that it should have high level of appreciation or high appreciation of what the job is about, how you got the job, how the job will be carried out, and where the job is, and expectation generally. All these things are essential because you are the prospective employee and you've gone through the process, you've been selected, and therefore it is not out of place that when you are asked about the job, you are not able to answer. So it's important. If you're not able to answer questions relating to the job that you are going to do, then it will be concluded that there is no genuine intention to do that job, and therefore you have failed to meet the genuineness requirement. So it's important. The second part is that If you are a partner of the skilled worker, you also make application to join your, or to travel with your partner or to join your partner later. You'll have to show genuine relationship, and that relationship is subsisting. It's important that you are able to prove that having lived together with your partner for 2 years or less or more, there's evidence to show that, yes, in addition to the marriage certificate which shows that you have married, or in addition to whatever evidence you have to prove that you have not married but you've lived together for 2 years and you are in a durable relationship, you have things to show that this is your husband or wife, you have been living together, and there's the intention to continue to live together. If you're not able to prove that, then as a dependent or a spouse of a skilled worker migrant, the conclusion may be that you have not met the genuine relationship test. So it's very important. What would they ask for? Now, when you are making the application, they will ask you, have you lived together for 2 years? You answer, and the next will be that provide evidence that you have lived together for 2 years. Provide 2 pieces of evidence. And these pieces of evidence we have discussed that could cover tenancy agreement, hospital letters, or any other official document, bill, what have you, addressed to you or addressed to both of you, but addressed to the same address. And therefore, the address where you live should appear on that document. So if it's bills, it's in your name, and other documents are also in the name of your spouse. It shows that you have both lived there. It's not just about showing that you are living together, also how long you have lived together. So if you claim you've lived together for 2 years, then your evidence should stagger across those periods to show that indeed you have met the test. This is what we have covered. We also chipped in that even though it did not relate to children, there's also a case that children must prove that either their parents have sole responsibility for them or both parents have shared responsibility. If both parents have shared responsibility, then they should provide consent. If one parent has sole responsibility, then that other parent cannot provide consent, because what they have said is that they take all the decision alone. So if you allow the other person to provide consent, then what you are saying is that the child can now have another parent to live with in wherever country they are in. This is what we have covered today. Thank you so much for your time.
And with that, I come in to draw the curtains down. Today's program has been very exciting, it's been very full of information, and I believe that you've learned a lot. And if you have any further questions, please call on BWF Solicitors at 214-218 on the Tottenham High Road, Seven Sisters. Call them Monday to Friday between 9:30 in the morning and 6 p.m. in the evening on 0208 493 7340 or 077 127 61884. Remember, BWF Solicitors gives you the opportunity to enjoy the streams and broadcasts that gives you free legal education Thursdays between 9 and 10 a.m. on Rainbow Radio International. Then on Fridays between 9:30 and 11 a.m. on BWTV. Then again, we climax everything over the weekend with the Community Under Law that comes your way between 4 and 6 p.m. British Summer Time, or whenever it is that it is GMT, it's between 4 and 6 p.m. My name is Owusu Frimpo on behalf of Padmo Dudu and Sheila Ankra, who do the aesthetics and the administrative work, my studio producer and manager, Professor Ade, and to the staff of BWF Solicitors, all the lawyers, Lawyer Charles Asma, Lawyer Eunice, Uncle Ben, the senior partner, Auntie Cynthia, and all the family from the front desk to the back house. Everybody is so included, and we're so happy to be working together with them. So until same time next week, when we come your way with another edition of the Community Under Law, keep the smile on, and remember to work with BWF Solicitors. Good evening.